by knowing something or dealing with another matter, it's now creating a bit of prejudice for your client. So let me give you an example. Actually, one of mine, when I just started out in practice, a legit conflict of interest, and how we dealt with it at the time. So I was working for a really wonderful big law firm, and I was, I think, maybe 2 or 3 years into practice, and we were dealing with it was construction, and the construction had gone wrong, and we were representing not the service providers. We were representing the guys who had paid these contractors to erect a particular building, and they just totally messed it up, and it couldn't pass the compliance certificates, and all that couldn't be done. And so we were dealing with these clients. These clients were actually my director's clients at the beginning, and they developed a very close relationship with me, and they asked if I could take over their matter. They really liked working with me. I was very happy to take the client over, and so I did. I think it was maybe about a week or two into the matter that I realized that the company which we were suing was actually owned by a family member of mine. And so I immediately, obviously I know my family members, I may not know what companies they own. And it was after I had gone through some of the documents, and I looked at the directors' names, and I was like, oh no. And so I went to my director, and I was honest with him. I said, listen, directors A, B, and C are my cousins, and we do have quite a good relationship. I wouldn't say like inseparable, but definitely, I mean, we chat, we speak on WhatsApp. So this is my family, and I don't know what to do. And so my director said to me, ask client, what should you do? You need to bring it to client's attention that there's a possible conflict of interest here. And let's just talk about the conflict. Why would there be a conflict of interest here? Because me having a personal relationship with the defendants, of course, could jeopardize my client's case, because I could be giving my my cousin's information. I could be sabotaging the case because, I want my cousins to win, or whatever other reasons they are. And it may sound ludicrous right now, and those of us that act professionally and ethically would never consider those things, but this is a legitimate concern, and it's a concern you need to bring to your client's attention. And the client does, of course, have the choice of whether or not you should step down as their attorney or not. In my circumstances, the client did not wish for me to step down. However, that was my choice. I could step down and say that I have a conflict of interest, and obviously I feel very uncomfortable suing my family. So maybe you need to find another attorney or get my directors to deal with it. One of the other reasons you can withdraw, and this may sound a bit far-fetched, but you can actually withdraw when your client has given you illegal or improper instructions. Now, I know for some of you, especially when you're starting out, you'll probably be like, who would do that? More often than not. And I think the longer you're in the field, the more you see it, and it's sad. And that is one of the times when you can say, I'm sorry, I'm not doing this, and you can withdraw, and you can terminate your mandate, and that's fine. If the client refuses to pay your deposits, as an attorney, you know that you are not required to even pick up your pen without monies in trust. That's why we are who we are, and why we're not counsel, because we are entitled to take our fees up front into our trust account, and then obviously bill our fees against that. So if the client does not pay your deposit, you can terminate your mandate and not proceed. So you could have, let's say for example, you decided to consult with the client signed on at the consultation, signed your mandate, and they were required to perhaps pay a deposit of 50,000 by whatever date it was, and they have not. You can terminate that mandate and say, I can no longer act for you as I'm not in funds to do so. You can also terminate your mandate, and this may sound a bit obvious, but you can terminate your mandate when you have a clash with the client, or some sort of trust has broken down. Now this does happen in practice. You may have a client who suddenly become very hostile for whatever reason, or they're particularly difficult. We, as in the legal profession, we call them red flag clients. They are red flag clients. One of the red flags is the client has had 25 different attorneys on their matter.